There are a lot of people who always will use the phrase, I have a right to do this, I have a right to do that. And so it occurred to me, especially this week, when there's been all kinds of pressures on our governmental system, to just stop for a minute, take a deep breath, and ask ourselves about civil liberties, civil rights, and where did they all come from? And it's more complex than one might think. So we'll see how far we can get with this. And most of what we're going to focus on will be spelled out in the Bill of Rights and how we got there. But it's more complicated than just the 10 members of the Bill of Rights. Equality. In a May 1987 speech that aroused much controversy, Marshall, Judge Thurgood Marshall, pointed out that the Constitution's preamble that begins, quote, "We the people," close quote, did not include the majority of American citizens. Women's and blacks, and we can also say, though he didn't say it, Native Americans as well. He called the Constitution defective from the start because it required a civil war and tremendous social upheaval to attain the system of constitutional government and its respect for the individual freedoms and human rights we hold as fundamental today. And we have to take these rights as being super precious to us. So this is why I thought we needed to explore this in a week when people were threatening to take away some of our rights. So they're spelled out, as you all know so well from your civics courses and others in your early childhood, youth, the Bill of Rights, those 10 amendments to the Constitution. But why did they need to add those? Why weren't they in the Constitution to begin with? And what is the purpose of the Bill of Rights? Why do we have to spell that out at all? Why do we have to talk about it? And we'll start with this.
Take a moment to think about the U.S. Constitution. What's the first thing that comes to mind? Freedom of speech, protection from illegal searches, the right to keep and bear arms. These passages are cited so often that we can hardly imagine the document without them. But that's exactly what the writers of the Constitution did. The list of individual freedoms known as the Bill of Rights was not in the original text and wasn't added for another 3 years. So does this mean the founders didn't consider them? The answer goes back to the very origins of the Constitution itself. Even prior to the first shocks of the American Revolution, the 13 colonies worked together through a provisional government called the Continental Congress. During the war in 1781, the Articles of Confederation were ratified as the first truly national government, but establishing a new nation would prove easier than running it. Congress had no power to make the states comply with their laws. When the national government proved unable to raise funds, enforce foreign treaties, or suppress rebellions, it was clear reform was needed. So in May 1787, all the states but Rhode Island sent delegates to Philadelphia for a constitutional convention. A majority of these delegates favored introducing a new national constitution to create a stronger federal government. Thanks to compromises on issues like state representation, taxation power, and how to elect the president, their proposal gradually gained support. But the final text, drafted in September, still had to be approved by conventions held in the states. So over the next few months, ratification would be debated across the young nation. Among those who championed the new document were leading statesmen Alexander Hamilton, James Madison, and John Jay. Together, they laid out eloquent philosophical arguments for their positions in a series of 85 essays, now known as the Federalist Papers. But others felt the Constitution was overreaching, and that more centralized authority would return the states to the sort of tyranny they had just escaped. These anti-federalists were especially worried by the text's apparent lack of protections for individual liberties. As the conventions proceeded, Many of these critics shifted from opposing the Constitution entirely to insisting on adding an explicit declaration of rights. So what was the Federalists' problem with this idea? While their opponents accused them of despotism, wanting to maintain absolute power in the central government, their real motives were mostly practical. Changing the Constitution when it had already been ratified by some states could complicate the entire process. More importantly, Madison felt that people's rights were already guaranteed through the democratic process, while adding extra provisions risked misinterpretation. And some feared that creating an explicit list of things the government can't do would imply that it can do everything else. After the first 5 states ratified the Constitution quickly, the debate grew more intense. Massachusetts and several other states would only ratify if they could propose their own amendments for consideration. Leading Federalists recognized the need to compromise and promised to give them due regard. Once ratification by 9 states finally brought the Constitution into legal force, they made good on their promise. During a meeting of the First United States Congress, Representative James Madison stood on the House floor to propose the very amendments he had previously believed to be unnecessary. After much debate and revision, first in the Congress and then in the states, 10 amendments were ratified on December 15, 1791, over 3 years after the U.S. Constitution had become law. Today, every sentence, word, and punctuation mark in the Bill of Rights is still considered fundamental to the freedoms Americans enjoy, even though the original framers left them out.
When you're looking at our Constitution and the Bill of Rights, you always need to keep in your mind that it is a bundle of compromises. That's how it came to be. And so it was not perfect, still is not perfect, but it was enough compromise so that it worked. It was finally, as it said here in the previous little video clip, it was ratified in December of 1791 by 10 of 13 states, or a different kind of time. It is rooted in the writings of people like Hobbes and Locke and Montesquieu, Thomas Jefferson, James Madison, and a whole lot of other intellectuals who were part of the Enlightenment period of the 18th century. When I say it was ratified by 10 of the 13 states, it was not ratified by Massachusetts, Georgia, and Connecticut at that time. Wasn't necessary because you only needed to have it ratified by 10. Finally, in 1939, just as a bit of housekeeping, they then ratified it. Civil liberties, which are also called negative rights, are limitations on the government. It's individual freedoms and protections articulated in the Bill of Rights. But we have civil rights also, called positive rights, protections provided by the government. This is done through amendments, legislation, judicial review, decisions, and executive orders. In the beginning, there were 9, this is the ingenious part of the Constitutional Convention. They met in the summer, hot summer in Philadelphia in 1787, and they were trying to decide how do they get this thing to work. They could have had the various legislatures in the states ratify it, but they decided, no, this needs to go to the people. And so they specified that each state must call a ratifying convention specifically for the purpose of ratifying the convention of the Constitution. And so that's what they did. But it required 9 in order to ratify. So the ratifying conventions were held, and it was in the 5-state convention. First of all, they finished the Constitution on September 17, 1787, and they sent it out for review by the various states. Immediately, virtually immediately, 5 state conventions voted to approve the Constitution. So by January 1788, you already had over half of the 9 that you need. But by then, the anti-federalists began to have concerns, and so they began to write their concerns, and there was a defense then that becomes the Federalist Papers that emerges out of this debate in the press during that time. And then we had the first real test of the Constitution in an influential state, in other words, one with population, came when both sides prepared for the contest in Massachusetts in January 1788, and it was a very vigorous debate. Here, influential older patriots like Governor John Hancock and Sam Davis, they led the anti-federalists. Further, the rural part of the state where Shays' Rebellion had occurred the previous year was an anti-federalist stronghold. Bitterly divided, month-long debate ensued that ended with a close vote of 187 to 168 in favor of the Constitution. So by June 1st of 1788, 8 states had ratified. Remember, what do we need in order to enact it? 9. June 18th to 21st, New Hampshire, way up north, it ratifies 57 to 47. On June 21st, they become the 9th state to ratify. But listen, you can't have this thing go forward unless you have the 2 big states, 3 big states actually. You have to have New York, and you have to have Virginia, and you have to have Massachusetts. Population-wise, they were the most influential. So even though New Hampshire had ratified, this still wasn't going to work. There were other debates going on. And on June 2nd to 25th, Virginia finally ratified 89 to 79, and so they became the 10th state. New York really had the most contentious arguments of all, back and forth, and finally, on July 26th, they ratified 30 to 27. Now, you'll notice that's very, very close. And the only way it happened was that some of the anti-federalists, knowing that this was going to happen anyway. Now, remember, there are 10 states that have ratified. They didn't want to be left out. And so they basically abstained. Madison, hugely influential in all of this. Among the various states, beginning with Massachusetts, and with the others as they reviewed and discussed this in their state ratifying conventions, 141 bills of rights were proposed. So Madison, who now is compromised with himself, and in the first Congress, he took and condensed the duplicative, because many of them said the same thing in a little different words, into 39, a list he submitted on June 8, 1789, First Congress. Among the influences were the Virginia Declaration of Rights, the Northwest Ordinance, the English Bill of Rights, and the Magna Carta. Now, when it got into the Congress, one of the first things they did is they said, no, 39, way too many. So they reduced it to 20 by July. And Jefferson, who was an anti-federalist, urging Madison, a federalist, then drafted it down to 17 amendments for Congress to consider. Congress passed 12 of them on September 25th, 1789. So the first 10 amendments, there are only 10 of the first, there were 12 that were submitted to the states for ratification, and only 10 are approved. So what happened to the other 2? Amendments number 1 and 2. First of all, amendment number 1 specified that when the population reached 50,000, they would yield an additional member for Congress. If that were ratified, and it never has been ratified, but it's still out there, it could be ratified, it would suddenly yield a House of Representatives with 6,600 members. I don't think that's going to work today, and it's never therefore going to be ratified. So what was number 2? Number 2 dealt with the compensation for Congress, and it sat there. It sat there until 1992, when finally the 38th state ratified it, and it becomes the 27th Amendment. It says basically that Congress cannot raise its salary during its term of Congress. Currently, we just seated the 117th Congress, and so they can enact a pay raise for the 118th Congress, but not for their own. The states adopted numbers 3 through 12, and those become the 10 amendments. Introduced in 1789, finally adopted in December of 1791. Now, there's a concept called incorporation that has happened in the 20th century and into the 21st century. Between 1925 and 2015, the Supreme Court, through a number of decisions, actually incorporated virtually the entire Bill of Rights into the 1868 14th Amendment, which is the equal protection of the laws and due process. In other words, one really powerful, good amendment, and arguably, other than maybe the First Amendment, it is the most important single amendment to the Constitution. It says no state shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Very powerful language, and it has changed our country very much for the positive. Many of these changes were really fundamentally based on race and gender. Now that's sort of an overstatement, but you get the idea that it was to correct the racial problems and gender problems, which all of you gentlemen probably are well aware of. The Warren legacy. Earl Warren Court, which from the 1950s and 60s expanded civil liberties more than any other court in history. Now, I've got to take a moment here to talk about social contract, because it's fundamental to what it makes our country work. What is a social contract? It's an implicit agreement among the members of a society to cooperate for social benefits by sacrificing some individual freedom for state protection. For example, you are not allowed to take your car and go without any consideration down the street and ignore traffic lights. Because if you did that, we would have chaos, and we would have accidents, and we would have harm. And so you have given up a right to your freedom of total movement in order to have that as a protection for you, because you know others will obey it as well. Social contract says basically that we are born perfect and complete, but in order to live with other human beings, it's okay when you're a single person, but when you're going to have to live with other people in a society, you have to give up some freedoms in order to make things work. So it's fair to say that any organization, a family of a husband and wife or two men, any family relationship, one or both of them have given up some rights in order to make that relationship work. Theories of social contract became popular in the 16th, 17th, and 18th century. Theorists such as Hobbes and Locke and Rousseau, the means of explaining the origin of government and the obligation of subjects. Social contract theory says that people live together in society in accordance with an agreement, sometimes written, sometimes not, that establishes moral and political rules of behavior. They can be explicit, such as laws or formal rules, or implicit, such as raising one's hand in class to speak so that you don't have chaos. All of these are part of a social contract. History of law. In order to know where our Bill of Rights and the rights that we enjoy as Americans come from, we need to take just a brief moment and look back at the history of law in civilization, because we were influenced by that. Over 3,000 years ago, ancient Egyptian law was based on the concept of Ma'at. Now, I didn't really research this much before, but I like this character. A goddess of truth, justice, wisdom, the stars, law, morality, order, harmony, the seasons, and cosmic balance, and characterized by tradition, rhetorical speech, social equality, and impartiality. 22nd century BC, in Sumerian, Namu formulated the first law code, which consisted of causistic statements, the if-then kind of thing. The great Hammurabi Code that came out of Babylonia around 1760 BC. All of these ideas, some pieces of them are incorporated in what we know as law today. Most of you are aware, in one way or the other, of the Old Testament, which we can trace back to 1280 BC, takes the form of moral imperatives and recommendations for a good society. And even if you're not religious, the 10 Commandments are a good way to live. The small Greek city-state of Athens had its various laws and rules, but they mostly were confined to small pieces of their society rather than a broad societal application. But there were ideas here that eventually our founding fathers read, and some of those are incorporated in what we wind up with. Roman law, even more important, and we'll talk more about that in a second, heavily influenced by Greek philosophy, but its detailed rules were developed by professional jurists and were highly sophisticated. World law, in ancient India and China, they had distinct traditions of law and historically had independent schools of legal theory and practice. Manu, this is a system throughout Southeast Asia, philosophy of tolerance and pluralism. The Muslims, of course, even today practice Sharia law. In India, the Hindu legal tradition, along with the Islamic, were there. Some substantial amount, they've been supplanted by common law when India became part of the British Empire. Other parts of Southeast Asia also adopted the common law system that came out of British tradition. Roman law, after the Romans established a republic in 509 BC, they created several lawmaking bodies representing different classes of people. At first, only the upper class patricians made the laws, but before long, the plebeians wanted that right as well. 60 years after the founding of the Roman Republic, they finally demanded a written code of laws because the laws were not in writing. The government authorities and creditors were abusing the people. And so we have finally 12 bronze tablets together that contained Rome's first law code. Called the 12 Tables, the code recorded important legal concepts such as rules to settle boundary and other property disputes, formulas to make contracts and wills, protections for debtors, rights of citizens such as the right to be represented by someone in a legal matter. So the unfolding. Very basic to everything that happens in the law and the Bill of Rights that we have in America starts with the Magna Carta in 1215, which compelled King John to agree to governmental restrictions and subjects' rights. I want to tell you, this King John was probably the meanest king that Great Britain has ever had. He was a real son of a bitch. You didn't want to cross him. He would be very, well, just called nasty to you. He needed to be controlled, and that's what they did. In America, the first document, I believe it's fair to say, that made it a governmental restriction was the Mayflower Compact, a set of laws governing behavior for the good of the people. We also have the House of Burgesses that comes into being during this period, 1642, it is, just an amplification that rules and laws need to be a basic part of what we're doing. All the colonial charters of the various colonies have charters, and there are, in fact, restrictions and rules and laws in there. The Petition of Right from 1628, an English constitutional document setting out specific individual protections, probably equal in value to the Magna Carta and the Bill of Rights of 1689. The English Bill of Rights was an act signed into law in 1689 by William III and Mary II, who were the co-rulers. The bill outlined specific constitutional and civil rights and ultimately gave Parliament power over the monarchy. This was the bloodless revolution. And then we have our own Declaration of Independence with certain specifications in there. The Articles of Confederation that governed us from 1781 to 1789. And finally, we have the Constitution, which is ratified in 1788. So the Bill of Rights. Now let's take it apart. First Amendment came about in 1791. Includes freedom of speech and the press, the right to assemble and petition for changes, the right to association. Establishment Clause, government cannot establish a state religion or favor one over another. Such issues: state support of religious schools, prayer in schools, creation teaching, faith-based initiatives. The debates on all of these things continue today, and many of them will never be finally resolved, but it's in this area that it takes place. And then there's the free exercise clause, where you are free to practice your own faith as you wish to practice it. Practice one's faith in prison, in terms of diet, length of hair, gatherings. How much of this do you do? These are issues, some of them unresolved. How long do you let people's hair grow? How much, if you have a particular religious diet, to what degree do we have to provide for that in our prisons? These are debates that never get fully resolved. July of 2020, a ruling of the Ninth Court of Appeals on the length of hair for Native Americans, and we wind up with a double standard for men and women. Can women have long hair and men cannot? How long can it be? All kinds of questions that never get fully, but these are issues. Georgia, in April of 2006, enacted legislation permitting elective high school courses in religion and public displays of the 10 Commandments in the courthouse. Now, is this right? Should this happen? Are the 10 Commandments exclusively religious, or are they moral documents as well? Pledge issue, First Amendment rights. This is the Pledge of Allegiance. In 1892, remember, there wasn't a Pledge of Allegiance until 1892. The Pledge of Allegiance, as you have grown up in all of the school that you went to saying repeatedly, did not have the word God in it. But we had a religious revival, if you would, sweep through America in the early 50s. The Red Scare of the 1954, with congressmen and presidential support, Eisenhower, they added "under God" in 1955. And also in 1955, "In God We Trust" was added to our currency. It wasn't there before. And it's controversial to this day. Which God do we mean? How about those people who have no belief in God? All of these are, so there are restrictions in terms of speech. Some restrictions on speech, more likely during wartime. If you have espionage, can't do that. That's not permitted. Sabotage against the security of the country, also not permitted. Treason, betrayal of one's country. Seditious speech, encouraging rebellion. Then there are, and we all perhaps know about these, libel, written untruths. You cannot libel somebody in our society. Slander, spoken untruths. Now there are a qualification to this. If you happen to be a celebrity, if you are an actor or actress in Hollywood or a public politician, you have therefore given away some of your restrictions in terms of what people can say about you. So people can say things and get away with them. Fighting words, you cannot incite violence. Perhaps yesterday, the question will be, if this gets to court, did the president on Wednesday, did he actually send some suggesting words that incited the violence that overwhelmed the Capitol? Or were his words not really so you can interpret them that way? Or was he clever? And I don't know what we'll find out. Obscenity. Most famously, Justice Potter Stewart said, "I know it when I see it. I can't define it, but I know it when I see it." I always have loved this statement by Voltaire, or at least it's attributed to him. He may not have actually said it, but he gets credit for it. "I disagree with what you say, but I will defend to the death your right to say it." This is also basically the code of the American Council on ACLU, the ACLU on am I saying that right? Huh? American Civil Liberties Union. That's what I really want to say. Forgive me. I've got a shot in my arm, so I'm thrown off. And then speech. We do limit speech things like tobacco and liquor. You cannot say anything and everything you want about tobacco and liquor these days. The press, clear and present danger, words used that may present an immediate threat to the public order, not allowed. Preferred person doctrine protects printed and spoken word, prime tools of the democratic process. And so we do let people make these outrageous claims in our political ads that we see. We tend not to punish persons for what they say, ultimately for only what they do. And then the Shield Law. 31 states offer protection to journalists, including California. People's right to know versus the government's right to know. So if you're a journalist, you should be able to protect the people who provide you with information. And that is the Shield Law. The right to assembly. All those people in Washington, D.C. clearly had a right to be there. They did not have a right to overwhelm the Capitol building, but they had a right to assemble so long as they did so peacefully, which they did not ultimately do. And so in this society, even though we don't like it, we have peaceful protests, parades, marches, demonstrations, etc. Do a lot of them. And there will be more and more of those as our population increases and becomes more complicated. It's a way of communicating between the public and the government, as well as one another. You do send messages, and they do make a difference. Sideshows, gang associations, well, are all of these permitted? Again, you can associate with a gang as long as you are not doing anything that will cause harm to someone else. Can we tolerate and permit Nazis, the Ku Klux Klan, and other bad organizations, or at least what I would judge to be bad organizations? And the answer is yes, they are permitted to exist. The US Constitution versus the Simpsons, a little piece of trivia here. McCormick Tribune Freedom Museum poll from 2006 said that 25% of Americans could name more than one freedom in the First Amendment. Only 25% can name one. On the other hand, at the same time, 22% could name at that time all 5 citizens. 1 in 1,000 could name all 5 freedoms. We don't know about our freedoms. We don't appreciate their importance. So bearing arms, this is in the Second Amendment, also adopted in 1791. So the question remains, not fully resolved, was there intent that this be for a militia, so that every state could have a militia, the right to bear arms, for home protection, for sport, all of which are uses for guns and other kinds of armament. But then we have the question of gun control. Does everyone have a right to have one of these powerful rifles or a machine gun? And for what purpose do they have it? And where can you restrict it? And sometimes you have restrictions that don't work. Chicago, I am told, has the most restrictive city gun laws in the nation. And some of them, and Chicago notoriously has the most murders of any city in the nation. And then we have the Third Amendment, also adopted 1791. This came because of the practices of the British during the Revolutionary War and before. And it says that soldiers cannot be housed in a private home without consent of the owner. This was particularly bad during the Intolerable Acts of 1774, when no town meetings or moving trials and closing Boston Harbor, not riot control, soldier housing, all of those were issues from the Intolerable Acts of 1774. Fourth Amendment, 1791. Unreasonable seizure and probable cause subject to interpretation. A crime has been committed or is about to be committed. So how far can you go in seizing and something? How far do you go? And it's a tricky area. Exclusionary rule. Illegally obtained evidence may not be used in court proceedings. 4th and 14th Amendments cover this. Miranda warning, recitation and explanation of accused rights upon arrest. You have the right to silence, to counsel. You've been told anything you say may be an incriminating statement based on the Supreme Court decision called Miranda versus Arizona in 1966, and it is now an essential part of our legal system. The 5th Amendment in 1791, grand jury, double jeopardy, self-incrimination, due process, life, liberty, and property. 6th Amendment, 1791, you have a right to a speedy trial. You have a right to know the charges. You have a right to habeas corpus, the body must be there. Public and impartial trial of one's peers. Everybody has a right to a jury trial, if you wish. Defense and counsel and right to face one's accusers. Many of those go back to 1215 and the Magna Carta. In civil cases, going before the judge, disputes between individuals or groups of individuals, divorce, child custody, personal injury, product liability, contracts, etc., and generally monetary awards for damages in civil cases. In criminal cases, these are illegal acts against individuals or the state. These are misdemeanors, sometimes felonies, they can be one or the other, can include confinement, fines, or both. Adversaries, the first time you hear something, it's called original jurisdiction. The plaintiff, the person bringing the charges. In a criminal case, it would be the government. The defendant is the person who is accused. On appeal, petitioner, the person filing the appeal, can be the plaintiff or a defendant from the lower court, and respondent, the opposing party in the appeal. Court glossary, some terms. In civil cases, you have the plaintiff, which is the person filing the action. The defendant is the person responding. The judgment is the award by the judge or jury. And penalties in civil cases are usually monetary or other relief for damages. In criminal cases, the plaintiff can be the state or the people of California. The defendant is the person accused. The judgment is verdict by a judge or jury, and the penalties in criminal cases may include loss of freedom, restitution, fines, and even death. Civil and criminal cases. Here's the trial progression of civil actions. You have a complaint that's filed, answer filed, discovery proceedings, that's where you go and find out what really happened, getting the facts together. You have motions filed relating to what you found in your discovery. Then you have pre-trial proceedings of various kinds. A trial by a judge or jury, sometimes it's what you choose, and termination by the judge or a jury verdict. You heard recently in many of the cases dealing with the election results, the judges simply threw out the cases. It doesn't feel like there was enough standing, enough purpose to move forward with the case. The types of offenses, felony, serious crimes requiring personal court appearances and state prison sentences from 16 months to life, death, or a heavy fine. Murder, rape, armed robbery. Misdemeanor, less serious, without the possibility of state prison. Could be some confinement, community service, and include selling liquor to a minor, public disturbance. Wobbler can be charged as a felony or a misdemeanor. Drug possession, domestic violence, grand theft, could be either one. And infractions, the lowest level, such as a traffic tickets, disturbing the peace, usually resulting in fines, and only rarely a court appearance. If you're talking about a criminal case, you see a somewhat similar process. I'm not going to read each one of them, but you see how it goes through various steps along the way. Some steps can be shortened, some steps can take quite a bit of time. The one that can take quite a bit of time are the discovery proceedings, where you need to do a lot of investigation to find out what's really happening. Criminal court, unanimous verdict, beyond a reasonable doubt. Civil court, not so much. 9 out of 12. Preponderance of evidence, one side more believable than the other. And you may not necessarily have 12 on a jury here either. Might be as small as 6. Seventh Amendment. Jury trials in civil suits where the value exceeds $20. How often do you think that happens today? Probably virtually every case meets that test. Juries date back to the Magna Carta, whereas one could choose to be tried by one's peers as opposed to being tried by the king. That's when you really didn't want to be tried by King John. The judge in a petit jury, all juries other than grand juries are petit juries. The judge decides that the evidence warrants a trial. Juries of 6, 8, or 12 are used to hear and determine guilt or innocence. Grand juries, these are large, 19 to 23, they use to assess evidence in developing charges. Used in very serious felony cases. Can overturn decisions made in preliminary hearings. They have investigative powers. Grand jury is always conducted in secret. It's a big case in Kentucky where recently Breonna Taylor was killed, and there was a grand jury investigation there, and lots of controversy about whether the trial record should be submitted to the public. Finally, under political pressure, it was revealed to the public. But otherwise, they are often conducted totally in secret. It's the district attorney presenting evidence. There's a famous thing that says most district attorneys can get a conviction by a grand jury for a ham sandwich because they can structure everything as they wish it to be favorable to them. The defendant is not present, and there is no cross-examination of witnesses. Roughly 23 citizens, 2 to 3 times a week, 4 to 6 hours per session. They are on it for 6 to 18 months. Now, they don't serve it every day that way, but they are called in with quite a regularity to do this. Comprised of independent and wealthy individuals. The Eighth Amendment, excessive bails or files, and dealing with cruel and unusual punishment, such as the death penalty. Interesting that plea bargains solve 90% of all criminal cases. Plea bargains can result in the end of that many cases. Now, this map may not be up to date, capital punishment, but there are quite a few states in the north, east, and the north who do not have capital punishment. And there are some states that have it, such as Tennessee and Kentucky, Kansas rather, where you can have the death penalty. I guess South Dakota to New York, but it's no executions are carried out. And then in the rest of the states, executions are carried out in varying degrees. Texas being the lead here with the most number. This map may be out of date, by the way, but you get an idea that there are very few states where you can totally avoid capital punishment. The statistic on the right I just pulled up, and that is true. 1,529 men and women have been executed in the United States since the 1970s, although executions have declined significantly over the past. And similarly, this chart is from 1999, so it's out of date, but you get an idea of the picture at least. The Texas, Virginia, Florida, Missouri, Louisiana, Georgia, and so forth lead in executions. States like Ohio, Idaho, Colorado, Pennsylvania, and so forth are way down on the bottom. And bills of attainder, detained and found guilty and sentenced without the benefit of a trial, and ex post facto laws, passing an enactment of laws that make an action a crime after the fact. Could have been legal when committed even. The United States Constitution forbids both of these. federal law under Article 1, Section 9, and the state law under Article 1, Section 10, the text of the Constitution says basically no bill of attainder or ex post facto law shall be passed. These were common practices in past societies, and they are bad, 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 and certainly not at all in tune with civil rights at all. Unspecified rights, the Ninth Amendment. The rights of the people not noted are not necessarily denied. These are non-enumerated rights. So this protects people from anything that nobody remembered to mention or to write down. The right to privacy. Justice Louis Brandeis in 1928 dissent opinion spoke of the right to be left alone. Right to privacy, First, Third, Fourth, Fifth, and Ninth Amendments, dealing with things like reproductive rights, Roe versus Wade, 1973, the right to die in Oregon in 1997, homosexual activity, Hardwick versus Bowers, that's Texas, isn't it? Privacy rights in cyberspace, which is a new field for everyone to worry about, privacy rights in government. And it could be that we're dealing also here with the Obergefell versus Hodges and the right for gay people to marry. The right to care, loving would certainly be part of that as well. In 2006, 18 states were considering 36 bills that would protect health workers and pharmacists who refuse to extend services based on personal or religious beliefs, including things like birth control, in vitro fertilization, physician-assisted suicide, etc. Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety, famously said by wise Benjamin Franklin, my favorite founding father, even though he had nothing to do with some of the things that happened. States' rights, the 10th Amendment, the last one, which reserves powers of the states. If not given to the federal government and not denied to the states, then the power belongs to the states, meaning the people. This is federalism at its very best. Reserve powers, residual powers, or residuary powers are the powers that are neither prohibited nor explicitly given by law to any organ of government. Such powers, as well as the general power of competence, are given because it's impractical to detail in legislation every act allowed to be carried out by the state. For example, establish local government, conduct elections, determine voter qualifications, regulate interstate commerce, provide for public health, safety, and morals, and maintain a militia. And another thing, the 14th Amendment. No state may pass a law depriving citizens of life, liberty, or property without the due process of law or equal protection of the law. Two of the most key phrases in any of the Constitution or the Bills of Rights. Incorporation doctrine, making the Bill of Rights applicable to the states through the 14th Amendment. Well, what about the Bill of Rights and the 14th Amendment? Where do we draw the line on safety versus liberties? Who determines our rights and protections? Are we willing to surrender our rights for the sake of safety? How much? Recall after 2000, at 9/11, we passed the Patriot Act, which was really quite invasive. And it finally became somewhat controversial, and they have not been able to get together a majority to renew it. And so it sits there, not alive and not dead. But it is a compromise between such things as our safety and how much, and who's responsible for regarding our protection. And finding the balance, victims versus the accused and the accused of society. We also worry about an erosion of rights and of security. And what about sex offenders, pornography, suspected terrorists? And that's that.